welcome. First meeting of the Criminal Justice Committee in 2026, and can I wish everyone a very happy new year. First of all, I apologise to everyone that I'm having to attend and convene this meeting remotely. This is due to, in part, bad weather, but also illness. And it's also the case that the current interpretation of our rules is that if a convener is participating at all, even remotely, they are required to chair the meeting. So in the event we experience any difficulties or interruptions with my remote connection, the Deputy Convener will chair proceedings until I'm able to rejoin the session. And I'm grateful to Liam Kerr for his assistance in this. So we've got no apologies this morning, and our first item of business today is evidence taking on the Prevention of Domestic Abuse Scotland Bill. And we'll have one panel of witnesses today, and I intend to allow up to 90 minutes for this panel. And I refer members to papers 1 and 2. So can I welcome to the meeting Pam Gosal, MSP, member in charge of the bill, Ros Thompson, Principal Clerk at the Non-Government Bills Unit, Ailey Callender, Senior Solicitor, Legal Services Office at the Scottish Parliament, and Charlie Pound, Head of Policy and Research, the Scottish Conservative MSP Group. So you're all very welcome. And just before we start, can I remind everyone to please be as succinct as you can in your questions and answers. And for ease of convening this session, I propose bringing in members in chronological order, that is working through parts 1 to 4 of the bill. So can I ask members to indicate to the clerks when they wish to come in, either with a question or a supplementary at the relevant point. So can I firstly invite Pam Gosal to make a short opening statement. Pam Gosal.
Thank you, Convener, and good morning, members. Happy New Year. I would like to begin by thanking you for the scrutiny you have undertaken so far on my member's bill. I have found it very interesting listening to all of the evidence you have heard and think I can most usefully focus my opening remarks on clarifying what my bill will do and what it will not do. I have been working on this bill for over 3 years now and went through extensive engagement, including 3 informal consultations with organisations and individuals, and formally there has been feedback through 2 official consultations. Therefore, I believe that the depth and views of my bill cannot be reflected by just 2 committee evidence sessions. Figures released last week showed that 66,000 incidents of domestic abuse were recorded in a space of a year, representing a shocking 10% rise, an increase from the previous year. It is therefore beyond dispute that domestic abuse is a serious issue and is not going away or getting better. The Minister's evidence suggested that much is being done, but we all know the progress is so desperately needed is not happening, and this has always been the basis of my bill. More must be done, and primary legislation is required to make this change. My bill sets up, under Part 1, a series of notification requirements for those convicted of the most serious domestic abuse offences. I focused on the most serious offences following feedback in my own consultation process because including lower-level offences could lead to those defending themselves being required to be on what I termed the register. I think referring it to as a register may have caused some confusion. It is not a standalone process. Rather, the data from the notification system will feed into MAPA and, by extension, MARAC. This information can then feed into the disclosure scheme for Domestic Abuse Scotland. There was much reference from the Minister during her evidence session to the potential for those who commit domestic abuse offences to be assessed as sufficient risk to fall under the other category under MAPA already. I accept that some of the offenders under my bill will be already covered by MAPA, but I don't think it is accurate to suggest that the option of including some individuals based on risk in this category in MAPA is a substitute for requiring all them committing serious offences involving domestic abuse to be included in the notification scheme. Do we consider all people committing serious domestic abuse offences should be monitored in some way? I absolutely do. and I believe evidence on the impact of the Sex Offenders Register and of MAPA demonstrates this will have an impact. I know it's not cheap, but given the scale of the issue and the cost to the wider society, the committee is well aware there are huge potential savings in the long term across public services that would be far more significant than the initial costs. It is, of course, very challenging to estimate the cost due to a notable lack of data on who is already in the system. But the estimated costs are 0.5% of the Justice budget. And let me be clear here, there is no suggestion from me that funding would come away from existing current frontline services related to domestic abuse to fund my bill. On part 2, there has been such suggestion that the rehabilitation measures will be new and separate to existing work in the area and therefore a duplication of effort. That is not the case. I am seeking to ensure that there is a pathway when someone is convicted so that they can receive rehabilitation, if suitable at every step of the criminal justice system, from court to prison to parole. When I began the Members' Bill process more than 3 years ago, I wanted to remove the postcode lottery as to whether someone is offered rehabilitation at the point of sentencing. The postcode lottery is still going strong. The rolling out of the Caledonian system and other rehab programmes have been painfully slow, while reoffending rates continue to increase. If the government's intention is to have rehab available across all local authorities, then why not support a bill that will drive this change? Similarly, on the rehab measures in prison, there are already statutory provisions being implemented on through care. I am not seeking to duplicate that. I am seeking to ensure that within these measures there is tailored through care, especially for domestic abuse offenders, so it is a complementary measure. On part 3, there has been strong support from stakeholders, as the committee has heard, in oral evidence organisations, including Scottish Women's Aid and Social Work Scotland, on the collection of data and the clear need for data on protected characteristics. Again, the suggestion is work is underway from the government. Why not commit to this data collection and primary legislation to drive this process on? The government memorandum suggests that there will be a burden on charities. I have met so many charities that already seek to collect all this data and information. That's what they are already doing. And I deliberately included the word in the draft bill on charity to ensure they do not have to collect this data, as it will be basically more on a voluntary basis. The bottom line is, how can we possibly provide correct support to survivors if we do not understand which victims are engaging with the process? There has been a suggestion new staff would be needed and trained within the criminal justice system if collecting such data became mandatory. Surely it is already a prerequisite in the actual roles involving traumatised victims that training must have been completed on how to best handle such delicate situations. On part 4, on school education, I have heard the argument repeated from the government that elements of the curriculum are not in statute. Why not? There is a precedent for this. We added a new example just there recently in December in passing my colleague Liz Smith's bill on residential outdoor education. The provisions in the bill are supported by Scottish Women's Convention and Shakti Women's Aid, and the provisions are deliberately drafted in a way that is not overly prescriptive about what form the education should take. Of course, considerations should be taken in the special schools, and considerations in mainstream high school are different, and my bill allows for that. What I don't understand is the suggestions we should leave it out, and it should be up to the local authorities to decide what schools it should be in. Again, this is a postcode lottery based on burdens already in schools, not based on the need for all children to have the ability to access domestic abuse education. I also do not accept the concerns related to UNCRC. My bill would be implemented by rolling out the terms of the current Equally Safe programme across Scotland, a programme the government endorses. How, in the case, can there be an issue about UNCRC compliance? Before I conclude, I would like to just make clear to the committee members that a number of issues that were raised during the evidence sessions were not fundamental issues of principle, but of slight issues of definitions and current wording of the bill. These things can be addressed at stage 2 and Stage 3. I'm happy to work with the committee to address some of these issues through the amendments. To conclude, Convener, I cannot put in words how passionate I am that this bill has been taken forward on this serious issue. I have worked on it for years. I put so much time and effort into this bill. Meeting victims and charities and many others have made me more determined to bring this change to this horrendous crime, and I'm happy to take any questions from the committee. Thank you.
Thank you very much, Ms Goulson. There's certainly no doubt about your passion and commitment to this bill. So I wonder if I can just open up with a broad question to kick things off. So, as you will be aware, Ms Goulson, the majority of the organisational evidence that the committee has heard it really reflects a lack of support, to be blunt, about the ability of the bill to achieve the aims that you've set out, and you're clearly very passionate about, and you've set that out in some detail already this morning. I wonder if you can maybe just, as succinctly as possible, maybe just reflect again on what evidence you have that the bill will, as it is drafted at the moment, achieve a reduction in domestic abuse offences and, in particular, reoffending.
Thank you, Convener. Just to be clear here, parts 1, 2 and 4, based on models are already in operation in Scotland. Particularly 2 and 4 are just ensuring that these provisions are in place. That's rehabilitation assessments and domestic abuse education across the country. And everybody knows that right now there's a postcode lottery out there for these provisions, and I want to make sure that it is in statute. Evidence that rehabilitation is a good thing is plentiful and accepted by everyone probably in this committee. Similarly, it's the same, the committee members will agree that education equally safe in schools is also a positive initiative. Part 1 is based on sex offenders register. Unless I'm missing something, no one has said in the past that there is no evidence for the sex offenders register not working or not being value for money. So I don't see why things are different for the domestic abuse offenders. I understand that organisations have concerns, but this is the first time such a register will be created for domestic abuse, so we don't have that exact data. But that happened probably when the sex offenders register happened as well. There's always a first time, and we know in the Scottish Parliament we have been quite groundbreaking on many bills. However, just on what I can say is the latest statistics show that 10.6% of sex offenders who are being monitored went on to commit another offence, compared to 27.1% for convicted domestic abusers. Lastly, I'd like to just say there's research being done in Convener, carried out by Anglia Ruskin University, which have found that to receive management under MAPA, offenders are less likely to reoffend, and that those that compared to those that do not receive that. So clearly you can see that the system is broken, Convener. Right now, domestic abuse cases are getting higher, and I just want to make that difference, and I believe that my bill will make that difference, and I hope I've clarified everything clearly. Thank you.
Thank you very much indeed. So just on, you mentioned part 1 in your response there, and I wonder if I can just stay with part 1 and refer back to the evidence that we received on the 10th of December from Detective Superintendent Adam Brown of Police Scotland, and he said that Police Scotland was not supportive of part 1 of the bill for a number of reasons, one of them being that the statutory management of part 1 might, and I quote, draw our focus away from some other processes that are already embedded in our response to domestic abuse, although I note in your opening statement you would contend that assertion. And secondly, that a key difference between existing processes and part 1 is that those other processes do not require a criminal conviction for intervention to take place. And I think that's a really important point that I certainly do acknowledge and think is a very important one. So obviously, in any response, convictions are taken into account, but as Detective Superintendent Brown said, they may not necessarily reflect the totality of the risk that a perpetrator poses. So I wonder if you've had time to reflect on the comments of Police Scotland and think about how you might consider amending Part 1 of the bill to take account of the views of Police Scotland, which, from a personal perspective, I consider are important in this context and worth considering further.
Absolutely, Convener. It's so important that this bill is open to the committee and the evidence sessions that we have taken, that we consider where we can put in amendments, and that's why we put the bill through those stage 1, 2 and 3 processes in the Parliament. So there are existing processes in place, Convener. We're all aware that there already is a sex offenders register. What I'm merely wanting to do is complement the system that's already in place, to work with MAPA, to also work with it right now. When you look at the sex offenders register, yes, you know, there's 95% of sex offenders on that register, but it's not very clear on data that how many offenders are there, also domestic abusers as well. I think that my system where...
I wonder, Ms Goso, my specific question was more about what your views are on the assertion that the resource requirement for Part 1 of the bill would draw resources, existing resources, away from services that, as you acknowledge yourself, are already under some financial strain.
Convener, I think I said it in my opening statement that this would be additional resources. So at no point in Part 1 am I saying that the police or authorities have to basically work off the budgets they've got. It has to be additional resources. And that's what I've made clear in my financial memorandum as well.
Mm-hmm. Okay, and I think just the other part of my question related to the fact that existing processes, again, don't necessarily always require a criminal conviction for an intervention to take place. And that's obviously different in the case of Part 1. Again, thinking back to Detective Superintendent Brown's assertion, the fact that someone has a criminal conviction doesn't necessarily reflect the full risk, the totality of a risk that someone may face. So again, I'm interested in your reflections on that point that was made.
Thank you, Convener. I am going to bring in, for technical issues, I'm going to bring in Charlie, my colleague, onto this question.
Yes, thank you, everyone. So on that specific point, I think that we definitely would accept the point that not everyone who presents a risk has been convicted of an offence. But I think the reason we've specifically modelled our Part 1 on notification requirements is because I would imagine that there's an element of proportionality, given that you're placing restrictions on these individuals' liberties effectively, even post serving their custodial sentence. Then, you know, the things like, you know, having to list what your address is and name and passports that you hold, things like that, is, I would imagine you could only do that lawfully under, you know, through having a conviction, i.e. going through a court-martial sentence. MAPA and MARAC and other systems like that, of course, operate more on a risk basis. And, you know, MARAC especially, as far as I understand it, is not a statutory process, and therefore there's sort of less burdens, you know, formal burdens placed on any offenders. So whilst we're not seeking to take away from that, and if anything, you know, Police Scotland, of course, are part of MARAC, they're part of MAPA. So the intelligence that they receive from our domestic abuse register will help them and empower them for, you know, the operation of MAPA, the operation MARAC, etc.
Okay, thanks very much. Okay, we will have to move on, so thank you for that. So I'm going to bring in Liam Kerr, followed by Sharon Dowie. Liam Kerr.
Thank you, Convener. Good morning, panel. I'd like to go back in my first question, Pam Gossel, to the convener's original question. Just drill into something. The conclusion of the University of Essex research into a register for domestic abuse and stalking offences in England and Wales concluded that, and I'll read a quote, "It seems evident that a register alone is unlikely to bring significant improvements in the criminal justice system's response to high-risk and serial domestic abuse and stalking perpetrators." Can you produce evidence such that the committee can see that that assertion is countered?
Thank you, Mr Kerr. Of course, a register alone will not fix everything. We know that. It's only part of the solution. You can see that there are 4 parts of my bill. We need to ensure that domestic abusers actually don't just get away with a slap in the wrist. That's why my part 1 is so important. Furthermore, I recently, I spoke about the stats showing that 10.6% of sexual offenders go on to re-offend, as opposed to 27.1% of all offenders. Also, I did mention how effective MAPA was with the research carried out by Anglia Ruskin University, that how basically people do not, especially offenders, do not go on to re-offend. So I think also in addition, there's a study from South Carolina found that sex offender notification and registration was associated with reductions in first-time offending. So, therefore, I do absolutely not, and understand that my register alone, part 1, will not just make sure there's a magic wand and there's a solution there, but it is part of the solution. Right now, you can see domestic abuse cases are rising year after year. We need to do something different, but complement the systems that we already have in place.
Yes, but we'd need evidence that it was going to work, and the problem we've got, the committee's heard a suggestion that, or evidence that it wouldn't work. But I take your point about the study. Perhaps if that hasn't been submitted already, you could send that in for us. I can see you might want to come back. Let me ask a further question, and then perhaps you can address that first point. Because we've also had evidence that the definition that's used in your bill of domestic abuse offenders doesn't capture the totality of risk. It might create a 2-tier system for domestic abuse offenders, and it might be inconsistent with the importance of having a consistent definition of domestic abuse in Scotland. Can you just give the committee your response to that evidence?
In terms of the definition, the term domestic abuse offenders, we have used the same offences that are contained within the Bail and Release from Custody Act 2023. So I do not see how there is any inconsistency there. For offenders who are convicted of these offences, we decided on, like I said, currently thresholds on the face of the bill having to be consulted with various after obviously consulting with various stakeholders, that I decided that it would be the best to target resources to the most serious and repeat domestic abuse offenders. This approach was suggested by the Law Society of Scotland in response to my initial consultation. But I'm happy to amend any thresholds in response to the evidence received by the committee and what the committee feels is right. Happy to amend.
Thank you. And final question for me then, is something I asked about in previous weeks. The committee has heard that there might be potential unintended consequences if the bill were to go through. So, for example, there might be a false sense of security for victims. There might be fewer guilty pleas and an increase in disputes in trials about sensitive information, and particularly any increased risk of retaliation, given that partners might stay with someone following their conviction. I think the committee is going to be very worried about this, so can you produce evidence that counters these concerns?
I mean, I don't accept this point because we heard that many women fear that reporting their perpetrator will make the perpetrator more angry. However, what victims want is to be protected from their abusers, and my bill will help to achieve that by imposing notification requirements on the abuser, so police and other justice authorities can act on that intelligence and protect victims more. If that means more perpetrators are going to court for their actions, then, I absolutely welcome that. Court should be less traumatic for victims, but this obviously should not prevent us from taking action to prosecute more domestic abusers. And also, you talked about retaliation. I did mention, in one of the questions as well, but on the opening statement, that it was very important that I listened to stakeholders. Like I said, over 3.5 years, I know I've lived and breathed this bill, Mr Kerr, and in relation to the retaliation, I made sure that I listened, that it had to be those serious offenders on indictment and repeat offences, that not everybody will end up, because we know retaliation happens, and what we don't want is those innocent people to be on the register. So it's more for the serious offences.
I'm going to press you, Pam Gossel, because I think it's really important, and I think I want to give you the best chance to counter what the committee's heard. Because the question I put to you was, we've had evidence that there may be very serious unintended consequences if your bill were to go through. It has the best intentions. I think we can all see that. But we have heard evidence that there may be serious unintended consequences. And so the opportunity I want to give is there any evidence that you can give to the committee that says actually these unintended consequences will not come to pass, and that in fact, if the bill's provisions are brought in, quite the reverse will happen, and the hoped for consequences are what is going to come to pass?
Right. I mean, I'm going to repeat, I don't accept this again. I'm going to be honest here, Mr Kerr, that if you look at the sex offenders register, when people are on it, do you think perpetrators want to be on it? Do you think perpetrators aren't angry? We can't shy away. And from the evidence you actually heard, there was one of the evidence that actually somebody had mentioned, I think it was Agnes, I'm not sure who it was, but said that we can't run away from it either. We can't shy away from listening to basically perpetrators feeling that they shouldn't be on this register, they shouldn't be tracked, they shouldn't be monitored. I think we need to basically look at, this is not about the actual perpetrator, this is about the victims. And you're right to say that, is there any evidence there that these people basically won't retaliate or they're on this register? What I believe is, look at the sex offenders register. People are already on that. There's already things happening there. I don't believe for a minute that we should shy away from our responsibilities, in this committee, or me as a member of Parliament, to say that these people need to be punished. It's an absolutely horrendous crime what most of these, especially women, are going through. But I am going to ask Charlie to see if there's anything he would like to add to it. But I certainly don't accept that point.
So I guess one particular thing that I'd cite, and you mentioned guilty pleas, is that we've, and Pam's been involved in these meetings we've had with victims where, specifically domestic abuse victims, where they've actually had a lot of trouble with guilty pleas, and the fact that in a lot of their cases, they'll have charges entirely dropped without their knowledge, without their consent, in these domestic abuse cases. So there's, if our bill means that people are, domestic abuse are more prosecuted, more of them are prosecuted, and the notification requirements, if you fail to comply with those requirements, that is a criminal offence. That's very clear, set out in the bill. If that means more of them going to jail, in our eyes, that's absolutely a positive thing. Ultimately, I think the Crown Office made the point of, there's very few offenders who commit a lot of the offences. If we're targeting them and we get them locked up so they can't go on to reoffend and cause harm to women, that's absolutely a good thing, and B, will reduce offending in the long run, because we're targeting those who are the most serious offenders. So I think that is something I would put as a counter to that.
I'm very grateful. Convener.
Okay, thank you very much. I'll now bring in Sharon Dowie, followed by Fulton McGregor.
Okay, thank you. Good morning. Could you set out specifically how the provisions in Part 1 of the bill will interact with the existing multi-agency arrangements for domestic abuse in Scotland, for example, MARAC, MATAC, MAPA, and in particular, why the current system, where some domestic abuse offenders can already be managed under MAPA, is not sufficient?
Thank you, Ms Dowie. As you know, not all domestic abuse offenders are being monitored under MAPA, and the Minister could not answer this point when I put it to her on the 17th of December. Indeed, the Scottish Government admitted that 95% of those monitored by MAPA are sex offenders. Of the processes like MAPA, MATAC and MARAC, that already exists in Scotland. My bill will simply extend to who can be monitored by these processes to domestic abuse offenders. So they would be managed in the same way that sex offenders are in that respect. The intention of my bill is not to override the work already being done on the systems in place, rather to complement that work. In Scotland, MAPA currently manages the risk posed by sex offenders, certain violent offenders, and those offenders are considered to be more a risk to the public. My bill simply adds domestic abuse offenders subject to the notification requirements to this list. While I accept that basically some of the offenders under my bill will be covered by MAPA, we have heard that, I do not think it is accurate to suggest that the option of including some of the individuals based on risk in this category in MAPA is a substitute, which I mentioned earlier on in my opening statement as well, for requiring all the committing serious offences involving domestic abuse to be included in the notification scheme. And I believe that you also asked that question to the Minister as well, and the Minister said they would get back, but I've not received any information on that 95%, which are domestic abuse offenders.
Okay, thank you. There was more questions on the data gap, but I believe that my colleague Pauline McNeill will come back and ask more questions on that. We also heard concerns, and the convener kind of mentioned that in her questioning as well, that we heard concerns introducing a statutory register has the potential to divert funding from existing multi-agency work or frontline services. So could you respond to that concern, and would it be possible to balance new funding for the proposed register and maintain funds for the non-legislative multi-agency work?
I mean, I did say, Ms Dowie, earlier on that these are additional resources, so that there will be nothing, I can't be clear enough, to this committee, and I know that was a big worry with a lot of the evidence we took, that, currently money is very tight, and we know that it's tight, that's why it's additional funding. The Scottish Government currently provides enough funds for Police Scotland to monitor notification requirements imposed on the sex offenders as a result of the Sexual Offences Act. I'm unaware of any, kind of representations from Police Scotland that have made to the Scottish Government about them wishing to alleviate themselves of existing burden. So if it's good enough for the sex offenders, why not domestic abuse offenders too, but on additional funding? Of course, funding decisions are a matter of the Scottish Government, but in the grand scheme of the Scottish budget, the financial costs imposed by this bill are relatively minor, and I did say it's 0.5% of the budget, which is very minor compared to what the budget is. As I said in my opening speech, I know that my bill comes with a significant financial burden, but domestic abuse costs the public purse around £7 billion across a 3-year period. It is, of course, very challenging to estimate the exact cost due to notable lack of data. We already know that because you heard yourself that data wasn't available. They don't even know that how many people are in domestic abuse are on MAPA. That data wasn't even available. But I do believe the estimated cost of 0.5% of the Justice budget is absolutely nothing compared to what the difference we will be able to make with this bill. I hope that answers your question, Ms Dowie.
Thank you. Convener, I've got a question in the financial memorandum. Do you want me to come in with that at the end?
Thanks. I'll bring you in at the end. At the moment, I'm quite keen for us to focus on part one, so I'll certainly bring you back in on that. Okay, is that you finished, Ms Dowie?
Yes, thank you.
That's fine. In that case, I'll bring in Fulton McGregor, then Jamie Hepburn. And just to remind members, we are still on part one.
Thanks, Convener, and good morning to Pam and others on the panel. Pam Gathal, Police Scotland already identify high-risk domestic abuse offenders and gather and hold intelligence on these individuals. Just wondering if you can say a bit more. I know you've already had an opening statement, but I wonder if you can say a bit more of how the notification requirements, how the system, how the bill that you're progressing will be different from the notification requirements already used by the police.
Thank you, Member. I did mention in my opening statement, and I also mentioned through questions, that we cannot just think about basically as a substitute that right now there are some domestic abuse offenders being monitored. That is not good enough if you were to go out and ask. We need a proper system that automatically puts those serious offenders and those repeat offenders into the system so that we can basically monitor them. That's hence why my part 1 of my domestic abuse register and the notification scheme is so important. It will not allow anybody to basically drop through the gaps. It will cover all those serious offenders. But right now, as I said earlier on, that when we did ask that question to the Minister did not know how many domestic abuse offenders were being covered basically by MAPA, and even on the sex offenders, that how many basically, because people that are on the sex offenders register will be on it for the sex offence, but it could be for a number of things as well. So there's a lack of data here. I hope the member understands. So it's very high to say, but my actual bill would create good, important clarity in relation to those offenders. We cannot just substitute. Some get caught by it and some don't.
I thank the member for that answer. I think my question was more around, though, the police already identify high-risk offenders, and how would your bill differ from that? How would it change that? Is more what you're saying there is because you don't know what the police, are you bringing the bill forward because you don't know what information the police hold?
I mean, thank you again for that clarity. The police don't recognise every single high-risk domestic abuse offender. It's very clear. We've heard enough stories in this Parliament, enough parents coming in here, families coming in here that are actually breaking down and distraught the fact that only if the system knew, only if the perpetrator was monitored, only if basically that, that one more chance for that safety, this person, and mostly are repeat offenders, they are not being covered. And you're right, absolutely right, the data isn't there as well. But I'm going to also bring in my colleague Charlie if there's anything to add to that.
Yeah, it's basically just to add that we again acknowledge, I think, in response to the convener's question, that there are others monitored, high-risk offenders monitored. But A, we do not have that information, but B, from the information the Scottish Government did give on the 17th of December, suggests that there is lots of domestic abuse offenders specifically convicted for domestic abuse that are not on that system, and so that is what it adds. It adds to that system, and therefore it will add to the multi-agency work that goes on across Scotland. So I think that is the part that we are adding here. We know that as a result of the provisions in Part 1, hundreds and possibly thousands of offenders are being added to that monitoring process, and that will, help the multi-agency, the multi-agencies to protect victims of domestic abuse ultimately.
Could I just come in back again, please, on this? I want to also highlight the fact that this is a very proactive approach. My actual register is, at this moment, we have the disclosure scheme. We have basically which I have said that my bill would work complementary with. But everything's about the actual poor survivor or that person out there that needs to know about, is the person I'm dating or I'm with, is that person a perpetrator? Is that person, being convicted before? The onus is all upon them, and we've heard that from the victims and survivors. This is a more proactive approach, and the fact that the police will sit with a lot more information than they've got today. They will sit with accurate data on a person's name, address, where are they living, and obviously I know there's lots of people talking about amendments to come in, where they work, what relationship they're in as well. It's very important, that information. Right now the police doesn't have accurate, up-to-date data, and on these serious offenders even, that they won't have that information. And I've actually heard that direct from police officers and people that worked in the police, saying the fact that those offenders, sometimes it's so hard for us to find a perpetrator when we go out there. We can go to 5 or 6 addresses and we won't have that accurate address. But my actual bill makes it, an offence if they do not provide up-to-date data and any circumstances changing as well. So that's so important that the police have that to hand in the agencies as well. So it's a very proactive approach as well.
That was actually going to be my next question on this, because it's around about the intelligence that the police hold, not necessarily some of the information on various lists or MAPA or various other systems. And I was going to ask, actually, you've went on to touch on it, have you had conversations with Police Scotland about the intelligence that they hold and how they use that and how they distribute that to other agencies where it's appropriate and such like?
Thank you for that. I did, absolutely. I've been speaking to the police right through on my informal consultations, and I did mention in my question I think it was on the 17th when I was in, I think that's when the police was in, that in relation to, I have already spoke to the police. I had a meeting with both the officer that was in and another officer as well, I think higher ranked officer as well. And on that call, I have to be honest, that the very first time I did my informal consultation meeting, the police absolutely were a bit sceptical when they asked me a lot of questions and they wanted a lot of changes, which I listened to. But see, when I did the call there in the summer holidays, I was actually shocked to hear all that information, that people coming in here and saying something else. Because if anything, I have the exact wording. What was said to me, that my bill would be groundbreaking to put something like this that has never happened in Scotland into place, but it's never happened in the whole United Kingdom or even outside. So it'd be absolutely a first for Scotland. But they also said that what we would be interested in is if you could put in things like relationships, things like that, where does the person work? And that was something that Women's Aid also, Marsha, said to me, that it'd be great if we find out if these people are working, so that when we have those people coming in, especially those victim survivors, we know that it's covered. So you're absolutely right. They need a lot more intelligence. The police have made it clear to me in the informal meeting, and they've said that they would welcome this information because it would help them in their investigations faster, and right now they have to go address to address to address because they have no current up-to-date data.
Okay, thanks, Ms Gothel. One further question, if that's okay, convener, looking at the screen. Yep. So the notification and monitoring system that you're proposing mirrors that's in place for sexual offenders, and I can understand the principle behind that. And I think when you first raised it in Parliament a number of years ago, I remember thinking to myself, I can understand where you're going with that. However, as the committee has taken evidence, we've heard quite a few concerns about that, and I'll just go through them. So the Scottish Solicitors Bar Association has told us that the parallel with sexual offences is limited. Police Scotland has stated that the tactical benefits from notification are more limited in domestic cases rather than the case of a sex offender. And Scottish Women's Aid told us that MAPA was never designed to work for domestic abuse. So what is your response to that evidence, which is pretty strong? And I think, as others have said earlier, we've really heard quite strong evidence against the main proposal in this area.
Thank you. That's three questions you put. I mean, I'm going to pass the first two to Charlie, but before I'll take the last bit on the MAPA, not designed for domestic abuse. When the Scottish Government were passing the Bail and Release from Custody Scotland Act in 2023, they specified that those subject to notification requirements under the Sexual Offences Act could not be released early via regulations. They also included domestic abuse offenders in this list under the same definition that we have included in this bill. So I absolutely reject the point that MAPA is not designed for that. But we've also heard, even though we don't have statistics, we've heard that MAPA already covers some of this stuff, but it's not there written in statute, or it's not there, to be honest, accurately in the fact that we actually lack of data, which we did ask the Minister. So, I don't think for a minute that yes, MAPA at that time was made for sex offenders, but MAPA's moved on. They're covering a lot of other things, but they're not covering it by statute saying that this has to be covered, and that's why domestic abuse offences, I said earlier on in one of my answers, was it's so important that we add this on when we have those 3 of 6 offenders, and then we have the serious offenders, then we have the risk to public health. I would like to add domestic abuse offenders to that. But I'll also pass on to my colleague Charlie for the first 2 questions you said.
Yeah, I think, to be honest, we're quite surprised to hear that, because there's quite obvious commonalities between these offences. They're both overwhelmingly committed by men, and the victims are overwhelmingly women. That is a very clear and obvious comparison, and it's a comparison that the Scottish Government themselves have cited, even in responses to questions on when the Minister was here on the 17th of December, making the point that some domestic abuse offenders were monitored by MAPA. So there's clearly an awareness of that. So to me, I have to say I was very surprised to hear that, because it seems that there is a very striking similarity between the motivations behind these crimes, and therefore this is why we not only want to include these 2 offences on a notification system, but of course the Scottish Government have sought to group them together in other pieces of legislation, like the Bail and Release from Custody Act, and I believe, if memory serves me correctly, it might have been the same case for the pandemic era legislation, which allowed for early releases too. So that's what I would say to that.
Okay. Thanks, Convener.
Okay, thank you very much. I'll bring in Jamie Hepburn, followed by Pauline McNeill, again staying on part 1.
Okay, thank you, Convener. My questions do relate to part 1, but I do have an opening question on the back of Ms Gozel's opening remarks. I suppose I think it's important because it relates to the process that we are going through. You suggested, and I might be paraphrasing here, that the full views couldn't be properly heard over the course of what you described as just 2 evidence sessions. I don't know, inherent within that, is there a suggestion that the process that the committee has gone through is deficient? Should we have taken longer on this, considering this bill?
I think, covering over 3.5 years nearly right on this bill, there's extensive information out there, even from actual survivors that I've managed to speak to. I totally understand and respect the committee. I mean, I sit in a committee as well, that I understand timetables are tight. So in no way am I saying the committee in any way has done anything wrong here. But what I am saying is, when you have extensive information out there, that I believe that, 2 sessions is not enough. I mean, I was just looking at basically, I'll give you an example of the organisations that basically wrote into the committee. You've got round about 19 organisations that have expressed some concerns and are against certain parts of the bill, right, which have 3 Women's Aid in it. And then you have basically 24 organisations that are in favour of my register, with some obviously conditions and amendments that they would like to change, and with 6 Women's Aid organisations supporting it. You can just see that the vast number of people here that have provided evidence to yourselves, and through my informal 3 consultations and the initial consultation, and then we have only 2 sessions in here, and we have certain people coming in that some have good views and some have bad views, but some also have a lot to add and amend to the bill as well. So, yeah, I do believe that it's not enough in just 2 weeks.
Just on that, I mean, again, you've said only 2 sessions. I mean, I understand I've taken bills through Parliament with the full support of government, and I recognise the work goes into it, and I understand the work that will have gone into taking forward your members' bill. You did say you set out 3.5 years ago the cut-off point for introducing a bill, a members' bill. Parliament was June of this year. You only introduced yours in May. You would accept, the point at which you've introduced it is inevitably going to limit the amount of time that we have to look at this.
I'm going to pass it on to Ross, because a lot of this is actually a process with Parliament. It's not up to me that if it was up to me, I would have probably put this bill in place a long time ago. There are processes that we must abide to, and obviously stages and certain things we have to go through. But at no time, I have to say, did I slack or did I think that I was basically, I should be in for June and that I could have done it earlier. I couldn't have done anything more earlier. I gave it enough time to make sure that every voice was heard and make sure that I went through the whole process that Parliament expects me to do. But I will pass over to Ros for that information for you.
Thank you. Good morning. Yeah, just to quickly set out, so the initial stage of a member's bill is policy development before it sees the light of day, before it's formally consulted upon. And that can be a lengthy process in relation to legislative competence assessment, equalities assessment, sustainable development assessments, all the things you'd expect to see for thorough policy development. This is a really substantial bill. This is probably the biggest members' bill in terms of length this session. It's a very complex policy area. It's working in a very complex legislative landscape in relation to criminal justice, and a number of other bills have been brought in this session that have interacted with its provisions. So beyond the policy development phase, you then have to have a 3-month consultation process. All of those responses have to... Yeah.
I understand all that. You know,
Okay.
I've been elected to Parliament for 18 and a half years. So I understand all the process, but there have been members' bills introduced sooner. But I'll leave it there. I suppose the fundamental point is there was a suggestion, there's a concern about the process that we've got through. But at the end of the day, you know, it was introduced in May, and there's limited time for us to take evidence. Just more specifically on part one, then you've mentioned a £7 billion cost to society over a 3-year period, and notwithstanding, we'd obviously want to reduce the impact on women, children. That's the fundamental thing we want to do, but clearly we'd want to bring down that cost as well. Presumably part of the intention of this bill then is to deter such behaviour in the first place, to bring down that type of incident, that type of behaviour. Is that correct? You know, this is to have some deterrent effect?
I think there is a deterrent there as well, but there's a number of other things as well to make sure the fact that, you know, there's a deterrent, but these people, the victims, are kept safe as well. I think that's a big thing in my bill.
I appreciate that, but deterrence is part of it. So I suppose that brings me on to my question, because the Crown Office, Procurator, Fiscal Service, Police Scotland, in their oral evidence, said they hadn't seen any evidence base that Part 1, the provisions of Part 1 of the bill, would act as a deterrent. So do you have an evidence base that would say to the contrary?
Yes, I think I did already cover these stats when we talk about a deterrent. It's a number of ways, obviously, after speaking to many organisations and especially individuals I'm going to talk about as well, that they did feel this would be a deterrent, that the person may not reoffend, right, okay, and they felt that this was in place, that certain things would have not happened. But I also covered some stats earlier on. I hope the member heard me, that I said the most recent stats show that 10.6% of sexual offenders go on to reoffend, as opposed to 27.1% of all offenders. So there's statistics clearly there showing that the fact that, you know, people are less likely to reoffend, right? Okay, and more when they're in domestic abuse. But I believe that if you look at the actual sex offenders register, you know, things have changed in that, and this is just mirroring a lot of the sex offenders registers. And we can't say that how much money that has been spent on the sex offenders register that's not working. I'm just sorry.
Police Scotland have responsibility for investigating crime. The Crown Office, Procurator, Fiscal Service, who have responsibility for taking forward prosecutions, criminal cases, who say there isn't any evidence base. They're wrong.
No, I'm not saying there isn't an evidence base here.
No, but they're saying there isn't. So
Sorry.
you're saying they're saying that they've not seen any evidence base?
On this, I think I've already... This is a brand new you know, domestic abuse register. And like I said earlier on, that I have probably backed up enough stats from research that has been done in other places.
I appreciate your position. I suppose I'm asking the question, though, do you think the Crown Office and Procurator, Fiscal Service and Police Scotland are wrong?
I'm not saying that they're wrong or right here. What I'm trying to tell you is, if you can make me, allow me to be clear here, this is a brand new bill. We've got lack of data here, right? Okay, the register is working in the sex offenders register. So what I'm mirroring over, I do believe that they should give this a chance. that at the moment, when you look at right now what's happening as well, everything they've put into place, and also a lot of bills that we put in, whether it's the government bills or members' bills, a lot of them are very first time. So I think it's about giving this a chance, and I've actually proved in stats that how this can work. I've also mentioned earlier on about basically another model, I think it was in Carolina, but I'm also going to bring Charlie in this for some information on this as well.
Yeah, just the South Carolina study found that an offender's notification and registration system was associated with reductions in first-time offending. I think that was published in 2010, so that's just to add to that evidence base there.
That counters what Police Scotland and Crown Office Procurator Fiscal Service are saying, that there's no evidence base.
Well, we're just putting out what our evidence is.
Okay.
We don't have government resources available to us.
Okay, well, they're not the government, are they? They're Police Scotland.
No, but
Office
obviously they work
Fiscal
with
Service.
With government.
Sticking with part one, then when we had the session with that included the Scottish Women's Convention, Scottish Women's Aid, I was quite struck by and actually quite surprised by the quite significant concerns they were raising about your Bill 1 area that Scottish Women's Aid raised in terms of their oral evidence session. They noted concerns that the provisions in Part 1 would provide a minimal amount of safety for victims or accountability for perpetrators, but would place a heavy bureaucratic burden on organisations. How do you respond to Scottish Women's Aid concerns?
Well, first of all, I think I mentioned earlier on that I had the privilege to speak to majority of the Scottish Women's Aid, and you've also received a lot of responses through the calls of view. So I'm not going to sit here and probably say that what Marsha Scott from Scottish Women's Aid said, did she say this from herself, or was she talking on Scottish Women's Aid's behalf? That doesn't seem
she was here representing Scottish Women's Aid, so we have to presumably take it face value. She was speaking on behalf of Scottish Women's Aid.
But then you probably heard my question to her, that basically what she had said separately to me and what she was saying there. But put that to aside, you actually have the calls of view, the evidence in front of you is probably, I'm sure the clerks have provided that I've mentioned how many Women's Aid are actually supporting my bill and saying that the register is a good thing. So I don't agree with that, what Marsha Scott has said on whether it was her behalf or Women's Aid, because you actually evidence the calls of view.
Surely we have to take it face value that she was saying it on behalf of Scottish Women's Aid.
Well,
she wasn't here speaking on her own behalf, was she?
No, to be honest, I'm trying to tell you the evidence here. If you're saying that she's speaking on, I'm giving you the counter-argument here, that you've got calls of view come in that clearly state that, if I'm not wrong here, that you've got 3 Women's Aid against the register, right, OK, talking about the difference in it. You've got 6 Women's Aid supporting it, but also I've spoken to Women's Aid, put that even to a side. So how can you say that what Marsha Scott has said, it's on behalf of all the Women's Aid? I don't agree to that. I'm
not necessarily saying that, and I'm talking about Scottish Women's Aid as a specific organisation. I'm just making the point, presumably she who was here speaking on their behalf. So in terms of the concerns that she laid out around a bureaucratic burden on organisations, do you not recognise that? You don't think that's a concern that we should take seriously? Yeah,
if I focus on the bureaucratic side and not on who Women's Aid at the time were representing, but I just wanted to also make it clear that it's not as clear what the committee can see, that one person coming in here and then your calls for view are saying something else. I mean, the evidence is very clearly in front of you. Is that person speaking on behalf or others? But put that to a side and talk at the bureaucratic side. I've not shied away at any time, I can make it clear to the member, to say that this bill would be as cheap. Of course, it's an expensive bill, but it's going to make a difference, And I think.
In fact, I've got a question about cost, which I'll come to in a minute. I'm talking about the administration, the bureaucratic burden on organisations, the work that would be involved for them.
For Part 1, I don't think so. I think a lot of the work in Part 1 would have to be done, which I've accounted for, basically, in the financial memorandum, would be basically covered by Police Scotland and other people, obviously, other organisations around it. But I don't see directly how Scottish Women's Aid and a charity organisation working with domestic abuse survivors, it would make it bureaucratic. If you could actually make it a bit more clear for me.
Well, I don't think they were necessarily saying it would be specifically them. I think they were talking about the burden it would place on Police Scotland and so on. I don't think they were necessarily saying it was specifically predicated on a burden on Scottish
right, okay, you're
Aid.
saying just Police Scotland. Well, I've actually mentioned that I'm fully aware, and that's why it's been accounted for. I don't think it will actually put, yes, well, there will be work to be done, but I'm also saying it will complement the current systems in place. I don't see where my domestic abuse added onto the sex offenders, the systems they have in place, would not work for this. But yes, there will be some bureaucracy. Of course there will, because that is with any bill. I'm sure every government bill that's going forward is full of bureaucracy as well. But it's important that we make sure that we provide the resources in my bill, and that's what I believe I have done.
But balanced against the concerns that they suggest, Scottish Women's Aid, that is, that it would provide a minimal amount of safety for victims or accountability for perpetrators. You think that bureaucratic burden weighed against that is worth it?
I don't agree with that. I don't agree at all that it will provide a minimum amount of protection. I mean, if you were to go out and speak to survivors, which I have done, I know the committee has not done, I have spoken to many survivors out there and many of survivors' parents as well, that this register would have a lot of information basically in it to make sure that they can keep those survivors and those victims safe, but also for police to monitor them as well. So I don't believe for a minute that this system is very minimal compared to what the actual result it will provide. It will keep women safe, especially women. I know that my domestic abuse whole bill is about that men and women, but I do have to say women are the biggest victims here. And I think it's important, if we can save that one life to make a difference, I do not count that as minimal. To me, I think it's a difference.
No, I take that point. One final question on part one, convener, relates to the resources involved. I'm not trying to financial memorandum because Sharon Dowie wants to ask questions around that. But you have suggested that there's no, in fact, you've said it more than once now, that there's no suggestion that the funding, this probably applies to the bill more widely than just part one, but no suggestion that funding for it should come from existing resource. So that begets the question, where should it come from?
Well, that's not, I'm not in government. If I was in government, I could give you that answer.
OK, well, let's pretend you are. Where should it come from?
I'm not in government, but it is only 0.5% of the budget.
But that's presumably allocated against existing priorities. And I appreciate this. Of course, it's for government to bring forward a budget, but it's your bill, so you must have some idea. Do you have any idea where it should come from?
No. Because I'm not, like I said, I am not the Scottish Government. I won't be probably sitting here to tell how the Scottish Government should be running their business. If I was in power, I would certainly be answering that question to you. But I would also say to you...
Well, let's suppose you were. Where should it come
I think
from?
I'm going, if you'll let me finish, please. I want to say the fact is that where the budget comes from, there's already many things happening. For example, Equally Safe is already, apparently it's going to be rolled out everywhere. Rehabilitation is going to be rolled out. So a lot of this work will be complemented. In relation to the register, yes, there is costs there. Now, that is up to the government where that money comes from. I don't have the balance sheet. And when you say, what if you were in government? I can't sit here and pretend I would be in government because you
told me that you could if you were. You just said you.
But
said
I don't have the balance sheet. What I'm trying to say, I think you're probing at something here that I'm making very clear to you. If I can make it even more clearer to the member, I am not in government, so I cannot answer your question because I don't have the balance sheets currently on where every penny is spent, whether it's on bad projects, whether it's on good projects. I have no idea. But I will say it is only 0.5%, and looking at costs right now, you're spending £7 billion over 3 years. It's a lot of money. So there you go. That's a saving if you wanted me to say where it would come from.
I freely accept I'm probing at the...
No, that's fine.
Well, that's kind of what
job.
we're here to do, but I'll stop there, Convener.
Thanks very much. I was just going to come in and move things on. I think we've well covered that point. OK, on that, I'll bring in Pauline McNeill, followed by Rona Mackay, still remaining on part one. Pauline McNeill.
Thank you. Good morning. First of all, I'd like to acknowledge the amount of work that you've done, Pam Gossel, and I know, having done the Members' Bill myself, a wee bit smaller, but I realise a lot of work involved in it. What I'm interested here in my line, the first line of questioning is not who's supporting it. I'm not interested in the evidence. What I'm interested in is trying to understand what the purpose of the register is in concise terms. So that's my first question. You have sort of answered this, but I'd like to hear a more concise answer on what is the primary purpose of the register as far as you're concerned.
Thank you, Ms McNeill. I think the primary purpose of my register is to keep victims and survivors safe, to make sure that that notification scheme is in place, that we know who those serious offenders are. And right now, like I said, that we don't even have the data to see that which ones are covered and which ones aren't monitored or covered. So I think my primary purpose here is to keep victims and survivors safe, and to make sure that we can do everything possible to make sure that those serious offenders and repeat offenders are monitored so that we know what they're doing, and that so police authorities then can notify those victims and survivors if somebody's at risk.
So it's the monitoring, you think, is the key thing that you think would make a difference to keeping women safe?
I think the monitoring and the register, but yes, I have mentioned earlier on, I think it was covered about the deterrent. I think there is a deterrent as well, which I've always said. I'm not going to go over
Can you just answer my questions, please? Because I'm trying to establish what the primary purpose is, and you're saying it's the monitoring. I obviously recognise there is a deterrent in anything you do. Could be. So it's the notification requirements that would be monitoring. So you don't think there should be any aspect of this that should identify risk of an individual offender at all? So basically, anyone who is convicted at 12 months or more for a prison sentence on indictment would qualify to be on the register if it's a domestic abuse offence. Is that correct?
Yes. Just on, when you talk about risk, I know a lot of this has been mentioned. I absolutely agree in that there has to be, I think currently there are some risk assessments being already done when it comes to even sex offenders, so I wouldn't take that out. I think there has to be a risk assessment somewhere in place. I don't know the full system.
But your proposal wouldn't involve a risk assessment because, if I've understood it, the requirement is that it is based on the prison sentence, on conviction, that puts you on the register. Yes.
I'm going to bring Charlie in, but I'm quite happy.
So there's no requirement prior to that to assess the risk. I've got a reason for asking that.
I'm going to bring Charlie in for the technical side.
No, it's based on the conviction, which, let's not forget is substantial to receive a 12 months plus.
Look, can we just take it as read that been on the Criminal Justice Committee for 5 years, I understand how serious it is. This is not why I'm asking the question. Do you understand? I'm trying to get some clarity, because there's an argument to say that if a smaller register, then there's more chance of monitoring the people who are going to put women at the highest risk. That's really why I'm asking that. But in your proposal, there's no requirement to assess risk. I think the answer to that is no.
It monitors existing.
There's no requirement. Okay. Can I turn to the question of MAPA? So I have a very basic understanding of this, so you can correct me if you think I'm wrong about this. But the basic underlying philosophy behind MAPA is to identify risk to the public. And whilst it goes without saying that domestic abuse and domestic violence is a very serious offence, what MAPA tries to do is identify where the offender is a risk to more than one person, and that's the victim and the public. Is that your understanding, or just correct me if you think that's wrong, please?
My understanding of MAPA is the 3 areas that I mentioned in the beginning: sex offenders, certain violent offenders, and those offenders that are considered to be continuing risk to the public. Yeah. That's my opinion of MAPA. And in that, like I said, there are people that have committed sex offences, but also committed other offences as well. And that could be a domestic abuse offence. But there is no standalone domestic abuse, and we don't even know the stats, as you know as well.
So you've been talking about MAPA quite a lot. How does your register proposal relate to the involvement of MAPA then?
I think I mentioned that early on, that it's my register would complement and work with it. So it's already working in those 3 areas. I want domestic abuse to be added on standalone, not something, by the way, that's a substitute, and that, if it gets flagged up, it comes
You
through.
want MAPA requirements on those offenders on the register?
No, I think MAPA, as a multi-agency, have to basically look at who's the offenders and everything. But it's, at the end of the day, I wouldn't work outside any of these organisations that I mentioned, including MAPA, no.
I'm still not clear. So, we know what MAPA is. Are you saying that there would be a role for MAPA in relation to the register? Would they go back and look and identify people off that register that they think was the same risk as the people they are currently monitoring?
I'm going to bring Charlie in for the technical side.
Yeah, so they basically automatically go on if you're subject to notification requirements.
So
it's
they would
specific.
all be covered by MAPA?
Yes, in section 15 of the bill, it states that.
You don't then see a distinction between the wider question of risk to the public and the victim and everyone on a register, which not everyone on that register is going to pose the same risk. So why would you want to use that resource of MAPA for every single offender on the register? I mean, what was the reason for that?
Because we believe they propose substantial risk, and this is why sex offenders go on, and similarly we believe these.
So you're saying that everyone on that meets the test and would be on the notification register would be covered by MAPA monitoring arrangements because you think they all pose a risk to the victim and they all pose a risk to the public, every single one of them. That's your position?
Yes, they've been convicted.
Okay. Thank you very much. Pam, you said that we need to do something differently, and I agree with you on that. But do you not think that to do something differently, we should maybe start at where the... Probably this is not part one, convener. Do you want me to leave that?
If you wouldn't mind leaving it, and I'll bring you in. If you just indicate when you want to come back in with that.
Okay, I'll just get another question on the register. Yeah, so I wondered if you thought that the children of those offenders on the register, if it were to come to pass, did you consider that there might be any stigma attached to those families where their father or their mother, for that matter, was on the register? Is that something that you looked at?
No, I didn't directly look at that, but I did speak to survivors and victims, and they felt that, that my bill was the right thing to do. I think if somebody basically has committed that crime, we need to make sure the right punishment is in place, the right monitoring is in place. So that would be the case, and to be honest, any bill, I think.
Yeah, that's fair enough. Just lastly, you will recall that I did question the Minister quite closely at the last session, Siobhan Brown, and I asked her whether she thought that, obviously they've said they're not supporting the bill, but she did eventually say to me that, yes, there were gaps, and I just wondered if you had given that some thought since the last session, because obviously any bill, if it gets to stage 2, you would want to amend it anyway. But I just thought if you'd given some consideration to how you could maybe get the government on board, because she did say there was a gap, and I just wondered if you'd had a chance to give her that any thought.
Ms McNeill, I'm absolutely open to work with the government, to work with the committee on any amendments or any ideas, and if there are any gaps that the Minister wants to basically highlight with myself, I will be speaking to the government, absolutely, because, like I said, I've spent a lot of time in this bill, not because of the time or the passion behind the bill, from growing up watching domestic abuse, and to help people. So I'm absolutely open to work with everybody on this to make sure that we have the right legislation going through to prevent this horrendous crime further happening. Yeah.
Thank you very much.
Thank you. And I'll bring Rona Mackay in, and then we'll move on to part two, and I'll bring in a question on part two. Rona Mackay.
Thank you, Convener. Good morning. I wanted to go back to get some clarification on a response you gave to the Deputy Convener earlier on around the definition of domestic abuse. As this is really, really important, because we had wrestled with this during the Victims and Witnesses Bill, and the possibility of a two-tier system being created is just, shouldn't be contemplated. Your response to the Deputy Convener suggested to me that you were unclear about that yourself, and if you could just clarify what you actually said and what you would be willing to do to clear that issue up.
Thank you, Ms Mackay. For clarity, the definition, I was quite clear, the definition of the term domestic abuse offenders, we have used the same offences that are contained within the Bail and Release and Custody Act 2023. So that's what I had said to the convener.
Just in relation to the fact that we've heard evidence that your register could create a hierarchy, because your serious offenders have been dealt with differently. So, your response to the Deputy Convener suggested that you were wavering on that, and I just want clarification on that.
No, I don't believe I was wavering on it, but I'm quite open, like I said, that if somebody feels there should be an amendment coming into this and happy to amend these thresholds, I'm quite happy to work with.
Very important, you do
absolutely
understand that.
But just on those thresholds, if I could tell the member that when I started this bill, right, one of the things that actually some of the organisations that came and gave evidence as well in here that said to me in the beginning was, from the very first thing, Pam, what do you do, especially when women retaliate? What do you do then, basically, there? That what kind of offences are you going to cover? If you cover a blanket on everybody, that what happens there? So that was one of the areas that I really listened to stakeholders and victims, and I made sure I made a difference in my bill. But honestly, Ms Mackay, I'm quite open to any amendments and to look at the thresholds, because I know it's been brought up in this committee that should we be covering only those on indictment, or should we be covering those on repeat offending? Should we be covering a lot more people here? I'm quite open, and that's why stage 2 and 3 are available there for your set mechanisms.
So just on your point about retaliation, Shakti Women's Aid were in and brought the issue up that if a woman retaliated in a self-defence way, she could end up on the register. How would you respond to that?
Well, I know, because I spoke to I've spoke to Shakti many times informally as well, and I heard that. That's why my bill is there for those serious offenders. It's not basically there for that, if somebody retaliates. That's why we made it such a high threshold. But just for technical stuff, I'm going to bring Charlie in on this. Yeah, I mean, we don't believe that the reason it was set at the sort of 12 months point was because we don't believe that there's likelihood that those offenders, people who are retaliating are likely to be captured by the register. But as Pam said, and would reiterate the point, if there's any proposals that anyone from the committee or government have to amend those thresholds so they're more appropriate, we're happy to listen. It's because ultimately we just want to make sure we're capturing the right.
So we take that seriously, because that was a comment that came from someone who works with domestic abuse victims day in and day out, and they raised that issue, which I thought was quite alarming. So if I can move on, a concern I have, and concerns that we've heard from witnesses, is that this register duplicates work that's already being done. And going back to my colleague Jamie Hepburn's point about an administrative burden, I want you to be clear, or give us your views on whether you think that's the case. And I have to admit, I was a bit alarmed when I heard you use the phrase, give this bill a chance. And do you think that's appropriate to bring in legislation to give it a chance? So I need you to be clear that you don't think that duplication is a problem,
I don't believe what you're saying. I don't agree with that. When I talk about,
it's appropriate to say you should give it a chance.
I think that terminology was used amongst other things as well, giving the passion on obviously the side I've spoke to victims and survivors. So I'm not sitting here.
I mean that's what you said 10 minutes
yes,
ago.
Yes, but I gave the evidence on where things are working, where things are not working, right through. I think I've been basically sitting here for about now nearly 50 minutes, and I've been grilled on quite a lot of the questions which I believe are absolutely right. I should be scrutinised on and asked, but what I won't take is the fact that when I say the words give something a chance, I think that has to be taken into consideration with all the information I have provided. And I don't believe for 1 minute that I have also answered this earlier on, that my bill Part 1 will duplicate anything. It will complement the systems already in place, and it will make sure that the people that fall through that gap, that we don't sit there just assuming that these people have been monitored somewhere or another. My bill will make sure in concrete that it will be, those people will be monitored.
And I appreciate your conviction that that's the case. We obviously have to take in the evidence that we've heard from other people, and those words, give it a chance. I mean, if every bill in this Parliament was brought in to give it a chance, that would be ludicrous. So I'm pointing out that amplifies my concerns that this bill may not, there may be an over-legislation problem here, because you say it will complement, and I appreciate that's your view. We've heard evidence to say that it would be a duplication of work that's already been done. And I'm just putting that out there, and that's one of my major concerns about this bill.
And absolutely, as a member of the committee, you're very well entitled to put that out. But like I said, to just sit there and use the words give it a chance and not have the context of all the 50 minutes of information I have provided, I think that's a bit unfair to myself.
Said those words.
But I said it in the context of all the information and evidence I have provided in 50 minutes. I didn't say it alone, sitting here with nothing just suddenly coming that out.
So were you quoting someone else saying it?
No, I'm not.
Is that your thought that we should give it
no,
a chance?
what I'm saying is that bills that have gone through this Parliament, what I'm trying to say is sometimes are the first. Right, and we've never did them before, and absolutely,
Ms. Gossel, I wonder if I can maybe just draw a line under this particular point. I think Ms. Mackay has made a clear point. I agree. The comments that Ms. Mackay has referenced were made by you, but I think we really do need to move on in the spirit of time. So thank you both. I'm going to end our questions on part 1. We are short of time, so I am going to propose that we extend the session by around about 15 minutes, if that is suitable for Ms. Gossel and others on the panel. And on that, I'm going to move to part 2. And I have one question just in relation to part 2, the assessment of offenders for rehabilitation. Now, Ms. Gossel, the committee has heard evidence about the inconsistency of availability of rehabilitation programmes and services. I don't think there's any doubt about that. There is scope for a lot more to be provided across Scotland. However, we also heard evidence that it wasn't particularly clear how the provisions in your bill would address this. So can I just ask you a very brief question, if I can ask for a brief answer? Do you agree that rather than introduce additional legislation with all that goes with that, there is scope for us to continue to develop and expand existing rehabilitation programmes and services that don't require the underpinning aspect around legislation?
No, I believe the statute is very important because it is a postcode lottery out there, but also the fact that certain local authorities have it available. There's also other programmes out there as well. I don't think mine's is not to say what that rehabilitation programme should look like, whether it's the Caledonian system. Mine's is to make sure that an assessment is in place from basically court to prison, to parole, and I think it's very important to put this in statute. And so far, it's not been done. It's not been rolled out. It's painfully slow. I've already said that, and I think it's important. And also, governments will change, and certain things will happen. Funding will move around. It's so important that rehabilitation is in place at every stage.
Thank you. And just on that, if I can press you, I'm interested in what rationale you think there is whereby introducing legislation would make a tangible difference in the ability of local areas to be able to improve and expand existing rehabilitation services.
I'm going to bring in Charlie for some technical stuff there.
Well, I think, again, we're looking to emulate models already out there. So, again, if we reference Bail and Release from Custody Act and the through care standards that were brought in through that was obviously a statutory provision. That doesn't mean the programmes are delivered. That's, ultimately remains a funding decision which the Scottish Government are responsible for. But we want to make sure that there is a statutory footing, and that is why the bill is worded to have those 3 different points that Pam referenced in court stage, prisons and parole.
Okay, thank you. If there are no members want to come in on part 2, I'm not getting any indication, then I think we'll move on to part 3, which relates to data collection and reporting. And I know, Ms Gosol, this is something that you've alluded to in your opening statement and your responses to questions. I wonder if I can maybe just come in with a question regarding collecting data. And ask specifically if you can clarify what the purpose of collecting the specific data that's set out in the bill would be. So, for example, is it in terms of improving services for victims? Is it about understanding domestic abuse and the dynamics of domestic abuse more widely? So I wonder if you could also clarify, and specifically in section 24 of the bill, the victims under 16 refers to children who are experiencing domestic abuse from a partner or an ex-partner, or children who are the victim of domestic abuse involving their parents. So I'm interested in a little bit more context to the data proposition that you have made in the bill.
Convener. The under 16 part and stuff I'll pass on to Charlie for the technical side, but I'll cover the areas you've mentioned earlier on. This is an area that I've really looked into quite, as you've said, rightfully mentioned. We need to improve these services. You talk about services. I think it's everything you've spoken about right now, because at this moment, we're not collecting data such as disability, ethnicity. And I can say, coming from an Asian background and also speaking to Shakti, Amna, Sikh Sanjog and many others, that I must say one size of service does not fit all. And we've heard that many times in this Parliament. I know that when you're dealing with a domestic abuser or a victim from an Asian background, it will be very different from somebody from a Western background, because you are dealing with not just the abuser, you're dealing with the family, you're dealing with the community, and it's such a wider effect that person needs. So we need to understand that if we're having basically, I don't know, say 100 people coming through from an ethnic background, right, or if they're whatever the background is, and they're basically facing issues, we need to make sure we have the right services in place, but not just the right services with organisations dealing with it. We also need to make sure that when this data is collected by the police are fully aware how to treat this sensitive issue, and to make sure that they know what they're dealing with. Disability. I came across it myself when a victim decided to reach out to me in very early days of my bill to say that they called the police. The perpetrator was the husband, and because she had a slur speech, the perpetrator said, "You've heard me many times," that they thought she was drunk, and they put her in a room and basically spoke to the perpetrator. So it's so important that we have the right services here to deliver for the right people. And why are we not? I mean, I find it shocking to this day we're not collecting these protected characteristics that actually we collect for so many different things, and also organisations out there, the charities. And if the committee wants to write to them, they're more than welcome to. I can tell you that all of them are collecting this data already. They've told me this, but I have still only put it in voluntary, so there is no actual onus upon these charities to do too much. But if they're collecting it, they will provide it.
Okay. Okay, I don't know if Charlie wanted to come in on that. Maybe
Yes, on the 16's point, just to say that, so the reason this was a separate section is basically, my understanding is there's basically a bit of a different data collection rules around under 16, so it's just giving Scottish ministers those powers to change the rules if they're not appropriate for those who are over the age of 16.
Mm-hmm. Okay, that's helpful.
Sorry, Convener, could I just also mention some evidence? The Independent Strategic Review of Funding and Commissioning Violence Against Women and Girls Review identified that there is currently a lack of disaggregated intersectional data and research with minoritised groups, and the review also highlighted that the current lack of core data set hinders the ability of public bodies to undertake work such as local needs assessment. So I just wanted to put that on record, that there is something out there in a review already that has identified that lack of data.
Oh, okay, thank you for that. I think we'll maybe leave that one there. I don't think there's any argument that there is certainly scope to improve data collection. Some of that really derives from I guess, practice and society moving on. Okay, I think Rona Mackay maybe wants to come in just with a question relating to some of the comments of the Victims Minister at our last session. Rona Mackay, over to you.
Thank you, Convener. Yes, I'll just quickly want to bring that in. The Minister for Victims and Community Safety said that there are opportunities to progress Part 3 of the bill through non-legislative measures, and that the Domestic Abuse Partners Roundtable has been carrying out a data mapping exercise to identify gaps and areas for improvement. So, can I have your response to that, and what would the provisions in your bill achieve that this work would not through non-legislative means?
Okay. Now, thank you for that question. Do you know, I did mention earlier, my bill proposal was published over 3 years ago, and the Scottish Government was fully aware that I'm working on the data stuff. We're over 3 years moved on now, and they still haven't published the type of information that was set out in my original proposal. They haven't did anything about it. Victims and charities want action. They basically want it now, and this bill would achieve that rather than waiting on a promise from the Scottish Government for over 3 years ago, and such simple information that could make a massive difference. I believe it's important. We need to put this in statute now and not wait for what the government is doing or not doing. It'll complement it, hopefully it will, because I have no idea what they're exactly doing. It's not in the public domain. But however, we can't wait over 3 years on such important data. There's people with disabilities, there's people from ethnic backgrounds. They want this information and this help and service today.
Address this with the government then?
I have. I spoke to the government in one of the meetings I had and said that I was doing this, and at that time they said they were looking at it. And so many, probably nearly a year on, we're sitting here. I've still not basically. All I keep hearing is, we're looking at this, we're looking at this. This is very important. So I think it's very important that we put this in statute. We do not wait for governments to change, things to change, or maybe not, promises to be broken. I think people need this information now.
Okay, thanks, Convener.
Okay, thank you. And I think Jamie Hepburn maybe wants to come in with a Part 3 question, and then we'll open it up to any other members before we move on to Part 4. So, Jamie Hepburn.
Thank you, Convener. Just a couple of areas on Part 3. And we heard some concerns expressed around, and again, there'll be maybe more specific things in the financial memorandum that Sharon Dowie may want to pick up on, but concerns raised by some of the organisations involved in data collection and reporting around the type of support resources that would be required for them to be able to do so. And in particular, and I think, to be fair, you did cover in terms of charitable organisations, so that might be a more voluntary approach, but the statutory agencies would be required to do it, as I understand from the bill. So how do you respond to those concerns that have been raised around the type of resourcing that would be required.
Mm-hmm. Thank you for that question. Now, in relation to the charities, like you've just said, I've made it quite clear it's voluntary. So we're not basically telling charities that have less funding and less resources to come out with this information. However, I cannot honestly reiterate even strongly in this committee how much great work the charity organisations are doing out there. They're collecting all this data already. I thought, because they have to collect this data to provide to the government and also other funding agencies to prove to them there's a problem or there's an issue we need more help with. So they've got to do bottom-up approach to provide information to prove it. There is no mandatory up there. And now, just going back to now the officials, you're saying that basically it'll be more work for example, the police collecting this data. I would think that when the police are putting this information on their database, and, you know, I don't know exactly the whole workings, but one would assume that to ask these questions at that time wouldn't be very onerous and they wouldn't be very costly either, because they already have a database. And I know, being an ex-trade and stands officer working with software and systems, that there can be tabs added on. But this information, when it's collated together and delivered and actually published, will make a difference, because that's where it will see where funding should go, what should be happening, where the gaps are. And also we can actually look at the difference as well, Mr Hepburn, between what the government basically or the police are recording and what organisations, because we also know that a lot of victims don't always necessarily go to the police at all times, that sometimes they will go to an organisation. So I think this data collection will help a number of areas. I don't believe for a minute that this is over-bureaucratic or resources are heavily needed in this area. I think we could fit this into the current systems very easily, and we should be doing this already.
We were certainly told that it would require systems upgrades for, I think, it was Crown Office, I think local government as well. So I don't think it is. Certainly, you know, we didn't quite get into the detail of, you know, adding tabs and so on and so forth. But you know, certainly, what I took from them that would be just a straightforward process. It would be resource intensive. Have you had any? Have you come up with any assessment? I think. Again, with financial memorandum too much, but I don't think you went into it in too much detail. Have you got any sense of what the cost might be?
I still don't believe there will be a large cost to this area. I did speak to the police on this, and that's how I said that I know that the systems, I don't know the exact ones they use. They said that certain things could be added, and it's quite easy that we could use this information. Now, for example, we know that 66,000 cases were reported to Police Scotland. We know that because somebody's collected that data. In that 66,000, how many were disabled? How many were back from an ethnic background? How many were other characteristics? We don't know, so we can't tailor our our funding or our services, or what services domestic abuse organisations are providing. I still believe, I'm not IT specialist, and I won't even pretend to be sitting here, but I can only say that what I was told, that there could be tabs included, and maybe that tabs may be included right through the system. I would hope that when you take information from one at the police at the time, that information has to be passed right through the systems.
Clearly had a detailed conversation with Police Scotland. What did COSLA say? What did the Crown Office say when you spoke with them about this? I
haven't spoke to COSLA on this, and I haven't spoke to the Crown Office, but I did speak to the police on this, and they said that could be done.
That's fine, but you don't know you've no information because you've not engaged with them on that one. And I think this is important.
Sorry, I did engage with Emma from the Crown Office, but I didn't ask this question.
Sorry, yes, I meant that on this. I have no doubt you have spoken with the Crown Office. I'd be surprised if you hadn't, but on this specific issue, you didn't ask about it. Okay, that's useful to understand. One area I think is important, and this is my last question on part 3, convener, is around the concerns that were raised that the manner in which it might be required that people are asked, victims are asked the same questions multiple times by multiple organisations could lead to some form of re-traumatisation, and that this isn't a trauma-informed approach. Have you considered that? Is that a concern to you? I mean, would be a concern to me. Is it a concern to you that this could re-traumatise?
Thank you for that question from the member. We're happy to amend the bill to ensure that the same victims are not asked the same questions about the same incidents. But the reason, multiple agencies are included within this part is to capture as much data as possible. But obviously, we want to avoid any duplication of questioning. But I would actually really hope that when a victim goes into a police station to report a crime, that information would be passed down right through the whole systems, right to the end, to the court. That information will be there. And only if there's a change in circumstances or a change somewhere would there be a change. But I would hope that our systems in Scotland would speak to each other right through, that a victim should never, ever be able to go through so much information.
The bill as drafted would require amendments. You agree right now that there's the possibility the bill as drafted could re-traumatise victims?
No, I'm not accepting that it could re-traumatise. What I'm saying is...
Why are you saying you'll amend it then?
I'm saying that we'll make sure that if there's any amendments to be brought in on this area, I'm quite happy to bring them in. However, I am saying that I don't believe that victims will be traumatised because this information that would be at the point of contact with the police, that information will be asked. Because actually we do ask a lot of information, don't we? If I'm not right, I'm sure the police ask a lot of information when that victim comes in. So this would be no different from asking that information to this information.
Okay.
If I can maybe conclude this line of questioning, just to add, I think, for Ms Gossell's benefit, I think the practice certainly across agencies that are responding to domestic abuse nowadays certainly does take into account the need to minimise trauma and therefore a lot of information sharing with consent is done across organisations. And I do share the concerns that Jamie Hepburn has alluded to with regard to the risk around trauma-informed approaches being compromised perhaps by some of the data collection proposals within the bill. Okay, I'm going to move on to part 4 and bring in questions from members. This is on school education, and I'm now going to bring in Katie Clark, and if any other members wish to ask questions on this, if they can indicate to the clerk. So, Katie Clark.
Thank you very much. And I was wanting to ask some questions round about this issue to do with how we deal with these issues in schools. And you'll have heard what the Scottish Government said when the Minister for Victims and Community Safety gave evidence to the committee, where she took the view that this would be out of line with the current discretionary and non-prescriptive approach to the delivery of learning and teaching. So I would like to ask you why you think that there should be something in statute in relation to domestic abuse, but also whether you think it might be helpful if these provisions were broadened out, because we know we've got a very significant problem with sexism and misogyny, including in school settings. So do you think that it should be wider than just domestic abuse, and it should be about ensuring that we're dealing with sexism and misogyny in the curriculum more widely, including domestic violence and violence against women and girls? So there's really two parts to that. Is first sort of your justification, if you like, as to why you think domestic abuse should be in statute, but also whether you've given any consideration to it potentially being broadened out.
Thank you, Ms Clark, for that question. Well, first and foremost, I believe that the domestic abuse education should be present in all schools and not, again, a postcode lottery that I mentioned earlier on with rehabilitation. We believe that if this early intervention were to be rolled out across the country, we would see that a dramatic change in attitudes towards domestic abuse that could see a permanent reduction, maybe in the number of crimes carried out. That is a chance I do not want to miss because, to be honest, we know how important early intervention is, and that's why I believe that we need to put this in statute. Again, we have been waiting for this to be rolled out. There are a number of different education programmes being delivered in schools. Some have them, some don't. There is no consistency there. Again, it's a postcode lottery. But also, I wanted to go back to what you mentioned in relation to, there's a lot about that what should be in the curriculum and what should not be in statute. I think I mentioned in my opening speech about my colleague Liz Smith's bill on the residential outdoor education. I think that answers a lot of the questions that sometimes things that one might think should be in a curriculum may not. That's just proved that the fact that this should be in statute and can be in statute, that there is a precedent already set. In relation to when you talk about misogyny, sexism and all the areas, I can only cover what I'm covering in my bill, right, which is very important because I think domestic abuse, like I said, early intervention is important, not just for the personal intervention with that child, that not to grow up to domestic abuse and understand it's a serious crime, but also if they see such a thing in the house or with others, that, there can be some kind of, if not intervention, awareness is more the word. But I won't shy away that there is no misogyny and sexism happening in our schools. I think it's a growing concern, Ms Clark, but on my bill, I think it's important that we cover domestic abuse because, let's face it, most of the people that I've spoke to, especially now the organisations that are dealing with this, because in the last year it's suddenly blown up and we're talking openly about this, they are talking about that a lot of the misogyny and even sexism stuff, that domestic abuse has got a role to play in some of them and sometimes not. So I believe for my bill, it's important we put it in statute. We make sure we have no postcode lotteries, early intervention, and that we're covering this area and not waiting again for another year, 2 years. Yeah,
I understand. And I understand your frustrations. Now, I know that there's a lot of different provisions in this bill, and I'm not sure exactly how much time you've been able to devote to this particular part 4 of the bill. But in terms of what's happening now, you've spoken about a postcode lottery. Have you got any examples of good practice that you can point to that is what you're trying to see rolled out throughout the country? Have you been able to, have you had the time to really look at that, given that there's so much in this bill?
First of all, over 3 years working on this bill, I have looked at each area very carefully. I have spoken to many stakeholders in each area, and I have looked at the fact that we have Equally Safe already out there. We're well aware of that programme, but mine is not to say what the programme will look like or how it will be shaped like. I'm not being prescriptive in that, which I said in my opening statement. Mine is to say that we...
Sorry, can I interject? Sorry. Have you got any examples of good practice? So have you been to a school where you've seen good practice, or have you got evidence from the consultations that you've done where people have said, at this school, this is happening, it was a really good programme, we think it had an impact? Is there anything you can point us to from the work you've done that gives us an idea of what it is that you're saying would be what should happen in every school?
So I've met with some of the women's aid organisations, some other organisations. There is a number of good things going on. In my area in East Dunbartonshire, there's also good things going on there as well. And they've got some other programmes, not just Equally Safe, and the fact that they do and they go into schools. I also know many other organisations. There's a number of things, but they are highlighting very clearly programmes to do with domestic abuse. So there's quite a lot. I can't fully name them. But I just also wanted to say that this was an area that actually took up quite a lot of support in our initial consultation. There was 94% support on education provision in this bill, that the fact that it should be statute. So that's quite high. 94%, compared to any of the others. The others were quite high as well, 89, 92 and all that. But 94, so I just wanted to highlight that as well.
OK, that's helpful. So we'll look at East Dunbartonshire because that, as you know, there's a lot of issues round about violence in schools in East Dunbartonshire in particular. The committee heard evidence that the provisions in Part 4 of the bill relating to the child being able to be removed from any domestic abuse education may not be compliant with international obligations and the UNCRC. Is that something that was raised with you at any point and something that's been considered when drafting the bill? I know that having gone through the process of a member's bill myself, I know that these matters are looked at often. So I don't know if you could perhaps respond to the suggestion that it may not be compliant?
I'm going to come back to that, but just on Ms Clark, if it be helpful for the committee, I can certainly email in and say some of the good programmes that are going on. Yes. What you asked earlier on, if that could be helpful, not just Eastern Bartonshire, other organisations. That would be very helpful. I will do that. Yeah. Yes, this is something. It has been considered during the drafting of the stage, and we believe the legislation to be compliant with existing law. Having said that, I would be happy for the legislation to be amended if the committee members feel like there is contradictions that needs addressing somewhere, or there's a piece of the legislation that you feel that something needs changing. My bill would, for example, be implemented by rolling out the terms of the current Equally Safe programme across Scotland, a programme that government endorses and have so far not heard any concerns under the UNCRC compatibility. So I don't believe that my bill is out with any existing law.
And when we took evidence, one of the issues that was raised was how the domestic abuse programmes and education potentially could be very traumatic, particularly for children who've directly experienced domestic abuse. Is that something that you considered in the work that you've done?
Absolutely. I've spoke to many organisations. Right. Currently, there's a lot of work being done out there, but like I said, some places have it, good practice, some don't. And absolutely, we need to take into consideration, and there's a number of programmes already being delivered in schools, not just with domestic abuse, other areas as well, that the schools do have to consider the sort of situation that you've mentioned. Yeah.
Thank you, Convener.
Thank you. I'm going to bring in Pauline McNeill, followed by Jamie Hepburn, still on part 4.
Thank you very much. Just to follow on from Katie Clark's line of questioning about the need to tackle misogyny in schools, you did say earlier, and I agree, that we need to do something different. And I wondered if you agreed that to get longer-term results in prevention of domestic abuse, domestic violence and sexual violence, that we do need to tackle misogyny amongst boys and young men. And I wondered if you thought that, considered that that might be more of a priority than trying to deal with offenders at the other side. Because if we don't try to tackle misogyny in the youngest boys, and I've actually done some work myself in schools with Katie Clark, and you hear boys as young as 10 and 11 that give you cause for concern about attitudes already forming. So do you agree that there should be some consideration to what we're doing at this end of the spectrum?
Like I said, Ms McNeill, I don't dismiss what's happening in our schools out there. Absolutely, it's a big issue, right, that's happening. But for my bill, it's important that we look at domestic abuse, and that's what my bill is identifying. But it's not to say that my bill cannot be amended. I think it's important that we have a proactive approach, because these people can go on to these children sometimes to be those domestic abusers. But also we need a reactive approach as well, that when things are happening currently, so what do we do about that? Mine is not to prescribe, like I said, what this education programme will look like. Mine is to say that the system and statute should be in place, that education should be provided to every child in every school, not a local authority or a postcode lottery.
So does that mean you don't think we should focus on boys specifically? Is that...
No, I think you have to be honest, on my bill, I have to say that the focus is domestic abuse, but I'm not saying that their amendments cannot be made, and I'm not saying that the focus, maybe somebody else is bringing through a legislation or something on that.
I just wondered what you thought. I mean, you don't think the focus in education should be on boys? I mean, I think we both agree that violence against women and girls is primarily committed by men. So, but you think the education should be not specifically?
No, I think it should be a number of things. I agree to what you're saying as well. There's not one thing here that one size fits all and it's going to be a solution. But if we can actually start off doing certain things and then look at other things as well and see what other people are doing as well, also what the government's bringing forward on that as well, I think it's a number of things. There is a major problem in the schools, but right now I know that in my education side that it has got a very strong backing that we need to put this domestic abuse in statute for education. Thank you.
And Jamie Hepburn.
Thank you. I want to turn back to the issue of UNCRC compliance. This wasn't an area, to be frank, that I particularly thought would be raised as an issue in the evidence we took, but the Crown Office Procurator Fiscal Service did flag it. It was almost flagged as an aside, but I was quite struck with what was said when we actually asked questions. Actually, it was me asked questions around this area at our session with the Crown Office Procurator Fiscal Service and the Law Society of Scotland. Now, you see you're very clear that there aren't any UNCRC compliance issues in your bill, but and I'll quote precisely from the official report from our last session. I asked Dr Forbes of Crown Office Procurator Fiscal Service if she got the sense that not enough thought had been given to the issue of compliance with the UNCRC at this stage. Dr Forbes replied, "I did not see it addressed in the policy memorandum, I have to say." And then in further questioning with on this issue, Dr Forbes came back to me asking if not enough due consideration had been given, and there was a possibility the bill as drafted might fall foul of our legislation with regard to compliance with the UNCRC. She gave a preamble but effectively said the answer to that question was yes. So why is the Crown Office and Procurator Fiscal Service wrong and you're right?
I'm going to pass on so you can probably hear the technical side of this to Ailey.
Good morning. As with all bills, UNCRC is considered during the policy development and the drafting of the bill. And as has been flagged, the provision around education which allows parents to remove children from domestic abuse education is modelled on Section 9 of the 1980 Education Act, which is the provision currently under consideration for amendment through the Children Withdrawal from Religious Education and Amendment of UNCRC Compatibility Duty Scotland Bill, which is still making its way through the parliamentary process. And I think that's where this issue has arisen. In preparation of the bill, as the member has mentioned, it's not prescriptive in terms of how the education is to be delivered, and there's a lot of flexibility built in terms of the required guidance to be provided to education authorities, and also the option of standards via regulations. And it was considered that these two mechanisms offered a vehicle of flexibility to ensure that that guidance was provided, to ensure that during the process of a child being withdrawn from the education, an opportunity was given for them to provide their view. That's not to say that, as the member has said, that an eye cannot be kept on how the current legislation going through Parliament develops and how it is passed in its final form, and whether there's anything to be taken from that in terms of the sensitive context of domestic abuse education. But it was considered that the regulations and the standards provisions allowed flexibility for provision to be made.
Dr Forbes said it wasn't. She couldn't see it addressed in the policy memorandum. So why is she saying that?
There is a statement on the compatibility of UNCRC.
Statement, but she's saying that it may not be enough detail. And having looked at it, I know there'll be a statement that says you consider it's compliant, but what working has there been done to demonstrate that this is given due consideration?
So there's a full risk assessment done in the background, a UNCRC risk assessment.
One final question from Ms Gozel. What would you be saying in response to the Crown Office Procurator Fiscal Service and the Law Society flagging concerns about UNCRC compatibility in any other bill?
I think Ailey's made it very clear that it's actually in one of the documents. Now, I don't
I'm
type
asking
the
about
document.
what you would say in response to them raising that.
I think I've made myself
any
very...
other bill?
No, I think we do need to see when the bill comes through. I mean, it's coming through my committee. We need to see the outcome where that happens, and that's when, if there's allowed for any amendments, we will do that. But at this moment, we're not being prescriptive, like Ailey said. So it's very high level, and it's not basically saying what the actual education programme should be. So I think we need to see what that legislation brings through as well. And if there's any change need to be done, we're quite happy to do that. But this is stuff that the non-bills team puts together, not I don't personally put it together, and I'm sure the member knows that. So they have put this information in, and if Ms Forbes requires that information, we're quite happy to send it to Ms Forbes as well.
Okay.
If I could just add as well that yes, we're happy to sort of make any changes, but B, I'm sure Mr Hepburn will be aware as well that the Scottish Government themselves have struggled with this. Indeed, their own UNCRC bill was struck down in the courts for
I'm aware of all that, but you're willing to make changes.
It's a difficult issue.
You're willing to make changes
sure
to the bill to make it
balance
UNCRC compliant, although right now you think it is UNCRC compliant.
No, at this moment, what we're saying, it's fine, yes, but obviously there are other things coming out, yeah.
Okay, I will have to draw a line under this line of questioning because we are well over time and we've still got one final question to bring in on the financial memorandum. So thank you for that. And I'll bring in Sharon Dowie. Sharon, over to you.
Thank you. So in the financial memorandum, in terms of part 1 of the bill, Police Scotland stated that they are not of the opinion that the significant investment of budget and resources needed to meet its requirements are proportionate to the potential benefit. The memorandum from the Scottish Government also stated that the bill does not seem to reach the right balance in what its outcomes would be paired with the cost to public bodies and charities. So what are your views on those statements?
You know, I believe that, I did mention this earlier on, Ms Dowie, that it's very clear we're spending, you know, the public purse is £7 billion across a 3-year period. And I'm only asking for 0.5% basically of the justice budget to work on this. So I think it will help and I think it will bring down costs. But I'm not going to sit here and think and say, even it's cheap, like I said, the bill, especially part 1, does cost. Now, the other areas I have highlighted through my questioning and through my opening speech that I don't believe there's significant costs in those areas that should be highlighted. The majority of the cost will be going down to the actual register itself. But on this, I would like to bring in, obviously, from the financial side, Ros and Charlie as well, if there's anything to add.
Thanks.
Thank you. I probably won't comment on sort of benefit versus cost, as that's a matter for the member, and she's just commented. But obviously, the financial memorandum sets out best estimates as far as is possible, based on available data. And in some areas, it was considered pragmatic to assume where there is a lack of data, to assume on the more sort of generous side in terms of estimates. So, for example, there is no clear information about exactly how many individuals are currently covered by MAPA from the domestic abuse offences listed in this bill who would be caught by this bill. And so the largest cohort that we could find was identified and estimates based on that. And that was from a series of parliamentary questions from the member. Okay. Charlie, would you like to add anything?
Yeah, and nothing to add, I guess, except the written questions are a matter of public record, and there wasn't too much data. So the Bill's team did an excellent job of piecing together what is publicly available to come up with the financial memorandum.
Okay, and just one final question. You obviously attended the Criminal Justice Committee on the 25th of June to give evidence in the bill and stated that your bill would cost at most £23 million, whilst resulting in £7 billion worth of savings over a 3-year average period of abuse. So, based on the views that you've heard from stakeholders and the response that we've had in from the Finance Committee on the cost of the bill, specifically the cost of setting up and maintaining the register, have your predicted costs changed in any way?
I think on those we will stick with the questions, and Ros, I don't think at all that the costs have changed. I believe that, yes, certain technicalities have to be looked at more in detail, that I am not an expert on. However, I don't believe that the costs we've put in that have changed significantly from what the evidence you've taken.
That's fine.
And Ros, is there anything that you want to add to that, or Charlie?
No, I don't think so. No.
Yeah, as I said, we were only piecing together the information that we were able to get from parliamentary questions and, you know, the prior to research. It's if the government had given us more data, we can obviously put together a sort of picture that has more evidence. But obviously, when we asked the questions of these government, we weren't able to ascertain a lot of that information.
Okay, thank you. Thank you, Convener.
Okay, thank you. I think maybe Jamie Hepburn wants to come in on the Finance Committee correspondence. I will have to ask you to be very, very brief, as we are well over time. Jamie Hepburn.
I will be, convener, and it picks up on Sharon Dowie's points, just to be more, maybe pick up more specifically from what the Finance Committee has said to us. They say that the assumption that you've made, Ms Gossel, in your financial memorandum, that each caseworker dealing with MAP and notification requirements has a case allocation of between 50 to 60 isn't correct. They say that's in direct conflict with Social Work Scotland set in the Bar report. This is Cosler, sorry, say this to the Finance Committee. It is in direct conflict with the Social Work Scotland set in the Bar report, which advised that 20 to 25 cases per worker was manageable and safe. East Lanarkshire Health and Social Care Partnership, South Lanarkshire Council and Police Scotland agreed with Cosler's view that your financial memorandum sets an unrealistic caseload target. Now, you've just said you don't think there would be any changes to your estimate, but given what they've said, how do you respond to that?
I'm going to bring Ros in, but I'm going to obviously start by saying that what Charlie just said, that we were playing with statistics and figures, what we had to hand. Unfortunately, what we got from the Scottish Government and what we got from other agencies is what we only had to play with. And we know, sitting in here, that the data wasn't even clear how many domestic abuse offenders were even on the sex offenders right from the government. That wasn't even clear. So we can only use the information. Absolutely agree, there may be some underestimates, there might be some overestimates, but I can only work with information I have. However, Ros will come in on some technical details on that.
Yeah, just to say that the financial memorandum deliberately provides a range of costs between 17 and 23 million, roughly, in order to allow for situations where there would be underestimates or overestimates. And I saw the evidence that you received that you refer to from Cosler, Social Work Scotland and the police. The financial memorandum was based on a University of Essex published report, and that included a figure of 50 to 60 cases per officer being the maximum number that can be managed well, but I appreciate that there's a lower range provided by Police Scotland. And
yeah, it's quite a significant variance, I would observe. And similarly, on part 2 at Cosler, it provided data to the Finance Committee from a local authority which suggests that the programme cost per person, this is the Caledonian programme, amounts to approximately £3,460 per person, whereas the cost outlined in your financial memorandum is £2,325 per person. I mean, again, that's a significant difference, isn't it?
I believe those numbers were taken from an answer from the Scottish Government for the purposes of the financial memorandum. So it's based off a written answer from 16th of May 2024. Yes, 16th of May 2024. But that's what we have publicly available.
Well, we now have this available from the Finance Committee, so what's the response to that?
I think we will have to look at it because this information came from the Scottish Government, and one would assume that the Scottish Government's information at that time was correct. But we will have to look at it, what they've said as well. But then we will have to see then who is right here. Is the Scottish Government wrong, or is, you know...
So you accept that the figures presented in the financial memorandum might be different from...
Well, I did say that there will be some over and under costing due to the fact that we can only go to make it clear to the member on the information that is provided to us, and the information at that time from the Scottish Government provided to us stated that, and that's what we clarified. And now, if there's something else saying somewhere else, we'll have to look at that and see whether the Scottish Government were wrong or right.
So it could be quite higher than...
I will have to close this down. I am sorry. I'm going to have to draw a line under this line of questioning. We are very, very over time, and I think we've got the gist of the point in relation to the variance in costing. So can I thank our panel, Ms Gossel, and your panel members for coming along today. I think that's been a robust session. We will now move into private session and we'll take a short suspension before we recommence. Thank you very much.